Hello students, welcome you all for the course of MBA Semester 3 Human Relations and Legal Framework. Today is our lecture number 27 and the topic of our today's discussion is Maternity Benefit Act 1961. So today we are going to discuss about this topic. So the objective of our today's session is help to understand the major provisions under the Maternity Benefit Act 1961. So this act has been primarily governed by means of providing the various forms of provisions for working women. Okay. So the contents of today's session are Introduction to Maternity Benefit Act 1961, Applicability of Maternity Benefit Act 1961, Persons entitled to maternity benefits, Notice of claim for maternity benefit, Dismissal during the absence on account of pregnancy, Prohibition of work during certain period, Right to payment of maternity benefit, and punishment under the Maternity Benefit Act 1961. So these are the contents. So we will see all these contents one by one and going for discussion. So first of all we are talking about the introduction to Maternity Benefit Act 1961. So this Maternity Benefit Act 1961, one of the very essential measure to protect the life of individual workmen, okay, particularly women workmen, those who are employed in the industries. So according to this Maternity Benefit Act, okay, this act will provide every woman entitled to get the maternity benefit as per the prescribed provisions, okay, which are entitled under this act, okay, as a form of medical bonus from the employer. So in this Maternity Benefit Act, okay, every woman will be entitled to get the benefit, okay, that is called as maternity benefit as a form of medical bonus from the employer. Now for what purpose this maternity benefit will be given to the women specifically, okay, particularly to safeguard the interest of pregnant women workers, okay, that maternity benefit will be given, okay, by the employer to the women workers, those who are employed in certain industries. Even according to the Constitution of India, to protect the individual life of the workman, okay, according to our Article 42, it is quite necessary to provide just and humane conditions of work to the working women, and quite necessary to give some sort of relief as a form of maternity benefit, okay. So the Constitution of India has been directed to the state and central government, okay, they need to provide some sort of benefit to the women workers, okay, specifically those who are belonging to the industry. Maternity benefit will be also aimed to protect the dignity of motherhood, particularly during the period of pregnancy, before and after. So this maternity benefit either in the form of leaves, okay, or in form of bonus value, it will be calculated and should be given to the working woman, okay, particularly to protect the health and other maintenance related activities of herself as well as her child, okay. So in that regard, that maternity benefit will be given to all working women according to this act. The applicability of this act would be applicable almost in many of the industries, particularly, okay, this act will regulate the employment of women in factories, mines, circus industry, plantation, shops and other establishment who are employing, okay, 10 or more persons, okay, or 10 or more persons in the industry. So it is quite essential that any industry, those who are employing 10 or more workers, and wherever the women workers are working, and these women workers are belonging to these industries, okay, this act would be applicable to all such working women wherever the employer they need to offer the maternity benefits to them, except the employees who are covered under the Employees State Insurance Act. Okay, employees those who are covered under the Employees Insurance Act, okay, that employees could not be considered, okay, to get the maternity benefit. That employees means that women employees. So any employees those who are entitled to get the benefits under the Employees State Insurance Act, okay, they will not be covered for certain period before and after the childbirth and provide the maternity and other benefits. So any working woman those who are belonging to this industry wherever 10 or more workers are working, and those who are not registered under the Employee State Insurance Act, okay, they will get the maternity benefit for certain period, okay, particularly before and after the childbirth, okay. So in this way the act would be applicable to such kind of women workers. So this act will also regulate the employment of women in certain establishment for a period before and after the childbirth and provide the maternity and other benefits, and the law has been extended to the whole of India. Now this act will be also provided the provisions, okay, when does the women employees, okay, those are working in this establishment, okay, they will get this maternity benefit. So that maternity benefit can be offered by the employer, okay, particularly for the period before and after the childbirth, okay. So during that particular period of time, okay, that maternity benefit will be given to the individual women employees. Now when we are talking about this applicability of this act, as we were discussed earlier, okay, women employees those are registered under the ESI schemes, okay, employee state insurance schemes, okay, they will not be covered under this maternity benefit act, okay. There will be other laws under which they will get some different measures, okay. So this act will be still applicable to the women employees who women employees in the establishment which are not covered by ESI Act, but as also to women employees employed in the establishment covered by the ESI Act, but who are out of this coverage because of the wage limit. So it has been mentioned in the Maternity Benefit Act, okay, that the act would be applicable to the all such industries wherever they are getting some minimum wages, okay. uh, if certain industries wherever the ESI Act has been applicable and the wage limit has not been prescribed over there, okay, that particular employees will be covered under this act, Maternity Benefit Act. So such kind of women employees, okay, they are not getting an appropriate wages who are registered under ESI Act, okay, the Maternity Benefit Act would be applicable to those women employees. Now when we are talking about how much would be the total maternity benefit the individual working woman that they will receive. So according to this act, okay, women employees are entitled to get the maternity benefit, okay, according to the rate of average daily wages for the period of their actual absence up to 26 weeks due to delivery, okay. So whenever the woman employees, okay, before and after, okay, the childbirth, okay, they will take total 26 weeks leave, okay, particularly that would be calculated on the basis of the average rate of daily wages, okay. So what will be the period of absence, okay, that absence before and after the childbirth, okay, that should be calculated and it should be issued to that particular woman employees. So the rate of average daily wage for the period of, okay, their actual absence up to 26 weeks, okay, due to delivery, okay, that should be offered to the individual woman employees. Now in case of further illness of that particular woman, okay, those are getting this maternity benefit due to childbirth, okay, if there is further illnesses arising due to any kind of pregnancy, okay, they are entitled to get some further leaves, okay, for the period of 1 month. So 1 month more leave, 26 weeks leave can be granted to that working women specifically, okay, those are entitled to get the maternity benefit. If suppose there are some further illnesses that are complications arises due to pregnancy, she can further take a leave of 1 month. So that provision can be made available in this maternity benefit act. Now persons entitled to maternity benefits, so who are exactly getting this maternity benefit? So maternity benefit will be obtained by any kind of working woman, those who are employed in the industries, as we were discussed earlier. Now what form of maternity benefit that they will get, that we recently seen, okay, the maternity benefit at the rate of average daily wage for the period of her actual absence immediately preceding and including the day of her delivery, and for the 6 weeks immediately following the day, okay. So either she will take total 26 weeks leaves, okay, before and after the childbirth, okay, that depends on the individual working woman, that how much leaves that she wants to take, okay. So from which date she would be absent, okay, that would be considered from which the benefit, the maternity benefit will be given to that particular woman employees. So either immediately preceding, okay, and including the day of delivery, okay, so from the day of delivery, okay, preceding and including the day of delivery, or for the 6 weeks immediately following that day, or after the delivery, okay, she can take the 6 weeks leaves. So the average daily wage is calculated on the basis of amount payable to her for the days on which she has worked during the period of 3 calendar months immediately preceding the day from which she has been absent herself on account of maternity, okay, or on 1 rupee per day, okay, whichever is higher. In earlier rule, okay, her wages would be, okay, the individual employee, those are entitled to get the maternity benefits, particularly working women, okay, their wages would be considered as 1 rupees per day, okay. Now it has been increased up to rupees 10. So minimum working has been required particularly for women employees, those who are entitled to get the maternity benefit. So women need to work for 3 calendar months, okay, so 3 months continuous service would be required, okay, in the industry, wherever after that she would be entitled to get the maternity benefit. To eligible for getting the maternity benefit, a woman shall have to work in an establishment not less than 160 days, okay, in the 12 months immediately prior to the date of her expected delivery. So before the delivery, okay, that individual working woman, okay, she need to work at least minimum 160 days, okay, including the leaves, okay, in the last 12 months, means within the 1 year. So that is a minimum criteria, okay, to get the leave, okay. She should have to continuously work for 3 calendar months, okay, and as well as, okay, she should be in service, okay, up to 160 days within the year. The maximum period for which the woman can be entitled to maternity benefit would be 12 weeks according to the old rule. Now it has been increased up to 26 weeks, means minimum 6 months absence of leaves that she can take, okay, due to maternity. Now when we are talking about the who exactly the what are the other provisions primarily on account of death, and who will receive the maternity benefits, okay. So let us see one by one. So there are several provisions are there with respect to that particular women employees, those who are entitled to get the maternity benefit. This includes 6 weeks up to and including the day of delivery and 6 weeks immediately, okay, following that day. Okay, so either before the delivery or after the delivery, means the birth of the newly born child. Okay, so before the birth of the child or after the birth of the child, okay, she can continuously take a 6 weeks leaves. That depends on that individual working woman. If the woman dies during the period, okay, the maternity benefit will be payable only for the day up to the including the day of her death. Okay, if the working woman died, okay, due to the delivery, okay, or any complications happens in the delivery, okay, so till death, okay, whatever maternity benefit will be there, okay, it will be given to that deceased employee, means that woman employee. Okay, however, if she delivers a child and dies during the delivery, okay, during the period of 6 weeks following the delivery, the employer will be liable to pay the maternity benefit for entire period of 6 weeks immediately following the day of delivery. Okay, suppose, okay, the woman employee, she dies after the delivery, okay, during the 6-month period of time. Here the employer will be liable to pay whatever form of maternity benefit, okay, for the period of 6 weeks. Now in case of child, if the child dies during the period, okay, the liability will be only up to and including the day of the death of the child. Okay, now if suppose the child of that working woman dies, okay, during or after the pregnancy, okay, whatever may be the period, the maternity benefit will be given to only that period, okay, on which the child was died. So it depends on the several conditions that the individual employee, women employees, that they will receive that much amount of maternity benefit. Now in case of woman dies before receiving the benefit, and the amount must be paid to the nominee. If suppose any of the woman employees, she dies, okay, during the pregnancy, okay, due to certain complications, so in that case, okay, her nominee or representative or any dependent, okay, that they will receive the maternity benefit. Now there are some other provisions are there due to miscarriage. Okay, if any kind of complications was happen and due, maybe due to poor working conditions at the workplace, so there may be the health related issues has been generated among the women employees, and maybe due to that miscarriages happens. So if in case of miscarriages, the woman must produce the relevant proof, okay, that she has suffered a miscarriage. Okay, even in case of miscarriage, the woman would be entitled to get the maternity benefits. Okay, but then these women employees has to give some sufficient evidences. So this will entitle her to receive the leave with wages at the rate of maternity benefit for the period of 6 weeks immediately following the date of miscarriage. So after the miscarriage, she can take the maternity benefit of 6 weeks leaves. Women who are ill on account of pregnancy, delivery, premature birth or child or miscarriage are also entitled as a period of absence and leave with wages at the rate of maternity benefit for a maximum period of 1 month. Okay, however, okay, that can be allowed to give by the individual employer, but sufficient proof has been quite necessary. Even due to miscarriage, if the woman she is not fit to work in the enterprises, okay, she can take 1 month further leaves, okay, even after the miscarriage, and she can continue the leaves for 1 month extra. So here the employer will be liable to give that 1 month extra leaves. Now notice of claim for the maternity benefit. If any of the women employees, those who wants to take the maternity benefit, so she need to give in writing to the individual employer, okay, or if she is not medically fit to come to the office, okay, her nominee or relative, they should have to give in writing, okay, the written notice, and that written notice may be submitted to the employer. Okay, The notice should start from the date, okay, she was absent from work, and provided that the date is not earlier than 6 weeks from the date of the expected delivery. Okay, it is very very important clause over here. The date of application would not be, okay, the date is not earlier than the 6 weeks from the date of expected delivery. Okay, so she can liable to take the leave, okay, before or after the childbirth. But before the childbirth, okay, how much time would be given? Okay, it should not be more than 6 weeks, remember. Okay, this notice would be also given soon after the delivery. If she is not able to come to the office, okay, even after the delivery she can give the written notice to the employer, and she can entitled to get the maternity benefit. Okay, either that the woman has been earlier applied or not, but she will get the maternity benefit just after submitting the application. So either she will take before the delivery, okay, or even after the delivery. That application doesn't mind that individual female employee, that they will get the maternity benefit in this case. On receiving the notice, the employer is bound to permit the woman to absent herself from work, okay, up till the expiry of 6 weeks after the delivery. Now, once the notice has been received from the woman employee, okay, she will be entitled to get the maternity benefit. Here, none of the employer will refuse, okay, the requirements. In case of woman who fails to give the notice, okay, this does not, okay, this entitle her from claiming the maternity benefit. Okay, if due to any reason, okay, maybe there are several reasons, okay, due to which if any of the woman employee she has not given any notice, okay, regarding the maternity benefit, okay, she will produce that notices even after the delivery, okay, just by making an application. Here the employer is still liable to pay the amount, okay, due to her, okay, whatever form of benefit that she will receive. So in this case, okay, the notice should be given to the individual employer. Okay, if suppose the individual woman employee she has not applied, okay, in that case her special case has been considered, but she will also receive the maternity benefit. But here we could not taken as granted that the woman employee did not apply, okay, for the maternity benefit. She need to apply even after the delivery also. When dismissal during the absence on account of the pregnancy, okay, now does the dismissal, discharge, okay, or any kind of retrenchment can be allowed during the period of pregnancy? So none of the employer, okay, they will refuse the employment, okay, to any pregnant woman, okay, and they cannot be discharged or dismissed, okay, or even retrenched. So dismissal during the absence on account of the pregnancy, okay, in case of the pregnancy period, or maybe illness during the pregnancy, okay, the woman employee should have to apply for the maternity benefit. Okay, here none of the employer, okay, they can discharge them, dismiss them, or they will retrench them, okay, from the employment. Okay, even in some cases, okay, due to pregnancy, some of the employers they are giving some easygoing work to the women employees, those who are present. So some sort of clauses has been there, okay, to, what kind of work that she would do, okay, during the period of pregnancy. If she is discharged or dismissed from the service, okay, she should still be entitled to receive the maternity benefit. If any of the employer, okay, do suppose there is a lockout or something else, okay, has been happen in the industry, even in such cases also the women employees that they will receive the maternity benefit. Okay, so any kind of employees, okay, those who have been even discharged or dismissed, okay, they will even receive the maternity benefit. The woman can be dismissed only if she is guilty of gross of misconduct. If any of the woman employee she has done any kind of indiscipline or misconduct, okay, she has been fired from the industry, she may be discharged, dismissed, or retrenched from the industry, okay, whether she will be liable to get the maternity benefit or not. She may be liable, okay, or may not be liable depending on the kind of misconduct that she has done, okay. If it has been causes to the loss of the property to the industrial enterprise, in that case she will not receive any kind of maternity benefit. Maybe some partly maternity benefit will be received to her. Woman who has been deprived of maternity benefit or medical bonuses within 60 days from the date on which the order has been communicated to her, okay, she can make an appeal to the relevant authority, okay. So after making an notice or application for getting the maternity benefit, so within 60 days the employer shall have to act and pay the maternity benefit accordingly, okay. If any of the employer that she has refused her requirements, okay, she can appeal to the respective authority and apply further for getting the maternity benefit due to pregnancy. This authority has final say on whether the woman should, okay, or should not be deprived of these benefits. So there cannot be any kind of conditions that wherever any kind of pregnant woman, those who are entitled to get the maternity benefit, so nobody or none of the employer could take a disadvantage. So certain rights has been given to specifically the pregnant women and those who are applying for maternity benefit. If a woman continues to report to work during the period when she is entitled to maternity benefit, okay, and she forfeits her claim to maternity benefit for the period. However, individual companies may allow the woman to take her leave as late as possible so that she may have more time to nurse the baby later on. Now it depends on the working woman that when shall she will take the maternity benefit, okay. If the employer, okay, and the employee, they are mutually deciding themselves, okay, to take the leaves later on, okay, and so that she will get some maximum time after the pregnancy and she will nurse the individual child, okay, very well, particularly after the pregnancy. Now that depends on the employer and the working woman, those who are entitled to get the maternity benefits. Now prohibition of work during certain period, okay, there are certain kind of particular work in the industry which can be avoided and which cannot be allocated to the working woman. So according to section 4 of this act, okay, no employer shall knowingly employ a woman in the establishment during the 6 weeks immediately following the date of the delivery. So any kind of employer, okay, after the delivery, they could not employ any working woman, okay, she would be liable to get the maternity benefit according to the law, okay. She should have to spend some time and nurse the child, okay, and they could not employ directly, okay, to that particular woman employees and allot the work. So maybe after delivery, miscarriage, or any kind of medical termination of pregnancy, so if any of the form of illnesses due to pregnancy that may happen, so within the period of 6 weeks, okay, none of the employer will allowed to work within an industry. It also specifies that no woman shall work in establishment during the 6 weeks immediately following the day of her delivery, miscarriage, or medical termination of the pregnancy. The women are being entitled, okay, and they are being empowered over here, okay, and they can take the leaves of minimum 6 weeks after the period of pregnancy, okay, for which she just have to produce the notices to the employer. It may be noted that if the pregnant woman makes a request to her employer, okay, she shall be given to during the period of 1 month immediately preceding the week preceding of 6 weeks before the date of her expected delivery any work which is of adverse nature or which involves long hours of standing, okay, which in any way is likely to interfere her pregnancy or normal development of fetus or is likely to cause her miscarriage or otherwise to adversely affect her health. Now if any of the working employees that she feels her health has been causing to be poor, okay, or some form of illnesses, maybe due to continuous standing or long standing hours, okay, or working on the machines, so she can apply to the employer and ask for to get some other relevant simple form of job during the period of pregnancy or even after the miscarriage, okay, or any kind of health related issues due to post or pre pregnancy, okay. Now that depends on the employer, that what kind of work that the employer will allot to them. So this will be called as the prohibition of work during certain period of time, okay, particularly during the period of pregnancies. Now right to payment of maternity benefits. So every woman employee are being liable to get the payment of maternity benefits, okay. So according to this act, okay, so she will get a minimum of 6 weeks leave specifically according to the average daily wage period, okay, and how much will be the leave of absence that she will apply, okay. And every woman shall be entitled to get from the employer shall be liable for the payment of maternity benefit at the rate of average daily wage for the period of, okay, of her actual absence, that is to say the period immediately preceding the day of delivery and the actual day of her delivery and her period immediately following the day, means before the delivery or on that delivery date, okay, she can make an application over there or notice to the individual employer, or even after the delivery she can make a she can apply for the getting the maternity benefits, okay, application she can apply to get the maternity benefits. The average daily wage means the average of the wages months payable for her, okay, for the day on which she has worked during the period of 3 calendar months immediately preceding the date from which she absent herself on account of maternity. The minimum rate of wage fixed or revised under the Minimum Wage Act 1948 or 10 rupees, okay, whichever is higher. Now, how to calculate the wage rate of the pregnant women, specifically those who are applying for the maternity benefit? So the first condition is what these employees, they need to work for minimum of 3 calendar months, okay. So 3 months working has been quite necessary to apply for the leaves, okay, or preceding the date from which she absent herself on account of maternity, okay. So from how long that she absent, okay, considering that minimum 6 weeks would be granted to get the maternity benefit. So the minimum rate of wages, okay, that are being fixed, okay, and it shall be decided under the Minimum Wages Act 1948. In earlier act 1931 act, there will be a 1 rupees wage rate for the women employees, those are applying for maternity benefit. Later on, okay, the amendments was there in 1948, okay, then the minimum wage rate for women employees would be 10 rupees, particularly those are applying for maternity benefit, okay, whichever is highest. A woman shall be entitled to get a maternity benefit if she has actually worked in the establishment of the employer from whom she claims the maternity benefit for a period of not less than 80 days, okay, in the 12 months immediately preceding the date of her expected delivery. Now, who will be entitled to get the maternity benefit, okay? If any of the women employee, those who are being employed in the industry, okay, from not less than 80 days in the last 12 months, okay, so within the year, okay, she should have to be work for minimum of 80 days. Now the these conditions has been improved up to 160 days, okay, as we were seen in the beginning. So according to old rule, okay, the minimum working period for the woman employees, okay, she will be entitled to get the maternity benefit, okay, that was 80 days. Now it has been increased up to 160 days. Now when we are talking about right to payment of maternity benefit, so each and every employer shall have to deliver this maternity benefit, okay, according to the law. The maximum period for which the woman shall be entitled to maternity benefit will be up to 26 weeks. Okay, so she will get the 26 weeks absence of leaves. Okay, and she can produce the relevant documents for which. However, the maximum period which has been entitled for getting the maternity benefit for women, two or more than the surviving children shall be of 12 weeks, of which not more than 6 weeks shall be precede the date of her expected delivery. Okay, if suppose there are two surviving children, okay, in that case, some particular form of benefit has been considered particularly for that particular woman. So further 12 weeks leaves would be given to that pregnant lady, and she will be entitled to get the maternity benefit. If the woman dies during the period, as we were already discussed earlier, okay, the maternity shall be payable for the day up to and including the day of her death. So on which date that woman employees died, okay, till that period the maternity benefit was calculated and given to the nominee. Where the woman have been delivered a child and dies during her delivery during the period immediately following the date of delivery, of which she is entitled for maternity benefit. If suppose say her child dies, okay, so she will get the maternity benefit only up to on that date, okay, on when that particular child died, okay, on that day only. If the child also dies during the said period, then for the days up to and including the date of up to death of that child, okay, whenever the child dies, even suppose she has taken a maternity benefit leaves, okay, up to only say for up to 6 weeks, okay, and 5 weeks has been completed, so she will get the leaves only up to that 5 weeks. After on completion of the 5 weeks, suppose the child dies, that leaves will be only considered up to 5 weeks only. A woman who is legally adopted a child below the age of 3 months or a commissioning mother shall be entitled to maternity benefit for a period of 12 weeks from the date of the child is handed over to the adopting mother or commissioning mother, as the case may be. Now if the working woman, okay, she is not being directly employing the maternity benefit, okay, and particularly she is in a position that she could not give the birth to the child, so she can adopt the child, okay, and the minimum age of the child that she can adopt would be a 3 months baby. That individual child the lady can adopt over here, and she will be liable to get the maternity benefit up to 12 weeks. So that condition has been there. So any kind of working woman, those who are adopting the child, okay, the child should be of minimum of 3 months, that is the condition, and she will be entitled to get the 12 weeks maternity benefit leaves. Now punishment under this act, okay, so any of the employer, those who are being not giving the maternity benefits, okay, such kind of employers are being violating the rules of and the provisions of this maternity benefit act, they are being punishable up with the imprisonment of 3 months with a fine of rupees 500 or both, okay, so there is a minimum fine of 500 rupees or 3 months imprisonment will be there. Besides, if the violation is related to non-payment of maternity benefit or any other amount, the court can recover this amount, okay, if it is a fine, and pay it to the aggrieved person. If any of the employee any of the woman employee, she has been applied for maternity benefit and the employer has been refusing her request or application, and they are not giving the maternity benefit, so she can appeal to the authorities and ask for the payment of maternity benefit, okay, the appropriate authority over here, they will give then justice to the individual employees, okay, those who are entitled to get the maternity benefits. So that is all about maternity benefit act. Thank you very much.